Good day, everyone, especially to Attorney J. Paler. I am Ashliwala J. Acsibar,
I am Joris Pino,
and we are here to present the Obligations and Contracts, Subsection 3, Tender of Payment and Consignation. This chapter covers the contents about what is tender of payment,
consignation,
requisites of consignation,
rationale for consignation,
tender of payment distinguished from consignation,
effect if consignation has been duly made,
and effects if after consignation the debtor withdraws with the authority of the creditor.
Good day, everyone. So again, I am Ashliwala J. Acsibar, and I'm going to discuss the Article 1256, which states if the creditor to whom tender of payment has been made refuses without just cause to accept it, the debtor shall be released from responsibility by the consignation of the thing or sum due. And the second paragraph states that consignation alone shall produce the same effect in the following cases: when the creditor is absent or unknown, or does not appear at the place of payment. Second, when he is anticipated to receive the payment at the time it is due. Third, when without just cause he refused to give the receipt. And fourth, when two or more persons claim the same right to collect. And lastly, when the title of the obligation had been lost. So let's first define what is the tender of payment and consignation. So what is tender of payment? Tender of payment is the definitive act of offering the creditor what is due him or her, together with a demand that the creditor accept the same. When a creditor refuses the debtor's tender of payment, the law allows the consignation of the thing or sum due. So, tender of payment, it is the monetary obligation to offer the payment, and if the obligation to give something, then you are actually offering the object, so your tender of payment is valid if you're tendering a legal tender. So, what are the legal tender? Money ang money or things na pwede i-compel ni creditor o i-accept kay kung dili i-accept na mahimo mora sipendi sa part ni debtor. So, tender of payment is an act of preparatory to consignation. So, what is consignation? It must be borne in mind, however, that a mere tender of payment is not enough to extinguish an obligation. Is the act of depositing the thing due to the court or judicial authorities whenever the creditor cannot accept or refuse to accept payment, and it generally requires a prior tender of payment. So, ang consignation is an act of depositing the thing due to the court or judicial authorities whenever the creditor cannot accept or refuse to accept the payment, and it actually requires a prior tender of payment. So, after mag-tender of payment, the creditor cannot accept or refuse the payment without a valid reason. So, what should you do as a debtor? As a debtor, you can consign it with the proper authority to extinguish a publication. So, mag-deposit ka of payment or a thing sa court, so you have to file a case for this matter. And as a debtor, it is not your fault and unfair ni sa part nimo kay wa gidawat ni creditor ang imong payment. So, to avoid the situation, you do the consignation. So, consignation it should be distinguished from tender of payment. While tender is the antecedent of the consignation, that is an act preparatory to the consignation, which is the principle and from which are derived the immediate consequences which the debtor desires or seeks to obtain. So, tender of payment compared to consignation. Tender of payment, it may be extrajudicial, while the consignation is necessarily judicial. And the priority of the first is to attempt to make a private settlement before proceeding to the solemnities of consignation. And take note na need pa mag-tender of payment for a valid consignation because that is the general rule. So, in order that the debtor may be released from his obligation by the consignation of the thing or sum due, these are the requisites for a valid consignation. First, There was a debt due. So, existence of a valid debt which is due, so di dapat mag-prescribe ang utang and it is should not be founded in illegal costs and consideration. So, check if it is due and demandable. Second, the consignation of the obligation had been made because the creditor to whom tender of payment was made refused to accept it, or because she was absent or incapacitated, or because several persons claimed to be entitled to receive the amount due, or because the title to the obligation had been lost. Third, previous notice of the consignation had been given to the person interested in the performance of the obligation. So dapat, before mag-deposit, so the consignation must be first announced to the person interested. Because without such notice, yung consignation as a payment, mahimo siya na void. Because the purpose of this is to give the creditor, sa mga person interested, a chance to reconsider this previous refusal. And so to avoid the litigation na maabot pa sa court, so in giving a notice, it could be simultaneously done. Fourth, the amount due was placed at the disposal of the court. So this is the actual deposit of the court or judicial authority. And lastly, after the consignation had been made, the person interested was notified of the action. So here, naay duha ka notice, which are the prior to consignation and notice after the deposit. So this is required under Article 1258, which should be discussed later. So this is mandatory kay if walay notice action, the consignation will be void. So next is the mandatory construction of the codal provisions on consignation. The Supreme Court ruled that the codal provision of the Civil Code dealing with consignation should be accorded in mandatory construction. So here is an example for a complaint for consignation. In one case, the Supreme Court held to witness the records revealed that Respondent Corporation did not file any formal complaint for consignation but merely deposited the check with the clerk of court. A formal complaint must be commenced with the trial court to provide a proper venue for determination if there is a valid tender of payment. While the rationale for consignation is to avoid the performance of an obligation becoming more onerous to the debtor by reason of causes not imputable to him. Next is the tender of payment distinguished from consignation. So as I have said earlier, tender is the antecedent of consignation, that is, an act preparatory to use consignation, which is the principal, and from which are derived the immediate consequences which the debtor desires or seeks to obtain. Tender of payment may be extrajudicial, while consignation is necessarily judicial. And the priority of the first is to attempt to make a private settlement before proceeding to the solemnities of consignation. So, I have example here relating to the Article 1256. So, D owes C a sum of money on due date of the obligation. D offers the obligation but C refuses to accept the payment without any justifiable reason. So what should the debtor do? As a debtor, you may go to the court and deposit ka og money, so it is called a consignation. And take note na ang pag-refuse ni C is without any justifiable reason. But if an iyang reason is valid and justifiable, ang consignation mahimong invalid. So that's all about the Article 1256. So next is Article 1257, which states, in order the consignation of the thing due to may release the obligor, it must be first be announced to the persons interested in the fulfillment of the obligation. The consignation shall be ineffectual if it is not made strictly in consonance with the provision which regulate payment. Para ma-release si debtor sa iyang obligation, so there should be a prior notice to the persons interested. So who are the person interested? So they are the guarantors, mortgage, solidary debtors, solidary creditors. So if may prior notice nila, the consignation is void. Then the second paragraph says that the consignation must comply with the provisions on payment. So mo to na-discuss ganina sa rules sa tender of payment na it should be in legal tender. So that's all about my discussion on Article 1256 and Article 1257. Thank you for listening, and on the next topic, which is the Article 1258, which will be discussed by Joris D. Pino.
So we are now on Article 1258. Consignation shall be made by depositing the things due at the disposal of judicial authority, before whom the tender of payment shall be proved in a proper case, and the announcement of the consignation in other cases. The consignation having been made, the interested parties shall also be notified thereof. So, the provision just answers the question how consignation is actually made. So, paano ba? Okay, like it said, it shall be made by depositing these things due at the disposal of judicial authority. And there must be proof that tender had been previously made, and meron ding notice to the interested persons that consignation will be made, and also after the consignation was made. So, ito lang din yung na-discuss kanina ni Miss Acsibar sa requisites of a valid consignation. And the rationale for consignation is to avoid the performance of an obligation becoming more onerous to the debtor by reason of causes not imputable to him. So, Article 1259, the expenses of consignation, when properly made, shall be charged against the creditor. So, well, dapat lang naman talaga na liable si creditor sa expenses ng consignation dahil kung hindi naman with his fault or unjust refusal to accept the payment, hindi naman naabot sa point na magkukonsign si debtor. Had the creditor accepted the tender payment, di wala naman sanang consignation, right? That's why we have the general rule that the creditor will bear the expenses of consignation because consignation of the obligation had been made, because the creditor to whom tender of payment was made refused to accept it without just cause. So we are now on Article 1260. Once the consignation has been duly made, the debtor may ask the judge to order the cancellation of the obligation before the creditor has accepted the consignation, or before a judicial declaration that the consignation has been properly made. The debtor may withdraw the thing or the sum deposited, allowing the obligation to remain in force. Ganito, what is the effect once the consignation has been duly made? Okay, ano ba yung epekto pag na-declare na yung consignation has been duly made? So, ito, the debtor may ask the judge to order the cancellation of the obligation. So, yung running of interest then is suspended. Okay, so pwede na i-cancel ang obligation. Pero sabi ni Article 1260, bago pa man daw ma-accept ni creditor ang consignation or bago pa yung judge mag-declare na ang consignation was properly made, pwede daw ma-withdraw ni debtor ang bagay o yung pera na diniposit niya. Okay, so if that's the case, yung obligation niya to pay the creditor will remain in force. Kasi withdraw niya. So, ito, it is the debtor's right. As a matter of right, pwede niyang i-withdraw prior to the acceptance ni creditor or prior doon sa declaration ng court. na the consignation was properly made. Okay, may right talaga siya to withdraw that thing or that amount na dineposit niya. After all, siya pa rin naman yung owner nung thing or that amount na na-deposit. Pag ganyan naman, hindi si creditor ang magbe-bear ng expenses ni debtor. Kasi although nag-ano siya ng consignation tapos winidraw niya, kinuha niya yung pera o nung thing. Since ginawa niya yon, si creditor hindi magcha-charge sa expenses sa consignation. However, okay, listen carefully. Pagtapos na, meaning si creditor has either accepted the consignation or the court has already declared it to be proper. Hindi na as a matter of right na pwede i-withdraw ni debtor yung thing o yung amount na dineposit. Okay? Pero pwede niya pa rin yun makuha or ma-withdraw. Pero dapat meron ng consent or dapat i-authorize na ni creditor. So, question. Kasi 'di ba may right nga si debtor to withdraw this thing bago pa man ma-accept ni creditor ang consignation or bago pa yung judge nag-declare na yung consignation was properly made. Now, question, how can the creditor prevent the debtor from exercising the right to withdraw is he consigned? 'Di ba? Kasi paano pipigilan sa pag-withdraw na i-withdraw yung dineposit na pera o bagay? Okay, so obviously, ang sagot lang dyan is by immediately accepting the consignation. Kung tinanggap mo na agad, di tapos na, hindi na niya pwedeng i-withdraw yung bagay o yung thing. Okay, so how about if the consignation was improperly made? What is the effect kung ang consignation was improperly made? So, the obligation remains dahil yung consignation is not effective as a payment. So, the consignation would produce no effect and an obligation ay nandun pa rin to pay to the creditor or to deliver such thing kung ano man ang obligation mo. Same din in case of dismissal of the case. So, kung yung case for consignation ay dinismiss ng court, consignation would produce no effect. So, we are now on the last article, Article 1261. If the consignation having been made, the creditor should authorize the debtor to withdraw the same. He shall lose every preference which he may have over the thing. The co-debtors, guarantors, and sureties shall be released. Okay, sabi, yung consignation having been made, meaning either the creditor has already accepted or the court has already approved the consignation. Ito yung sinasabi ko kanina, na pwede pa rin ma-withdraw ni debtor if authorized ni creditor. Pwede niya pang i-withdraw yung dineposit niya. Sabi ko nga kanina na hindi na as a matter of right ni debtor. Ang thing ay magiging parang privilege na lang kasi dapat may authorized si creditor. Okay, pero ang sabi, pag pumayag daw si creditor, ano ang epekto? Obviously, first, the obligation remains. Andun pa rin yung obligation ni debtor kay creditor. And second, creditor loses every preference. Mawawala yung priority over the thing. And last, co-debtors, guarantors, and sureties are released. So, unless nagbigay din sila ng consent na i-withdraw ni debtor yung dineposit. So, now, example, Aljor is indented to Joey in the sum of 10,000 pesos. Tapos, si Ashley ang guarantor. On the due date of the obligation, Aljor tendered payment, pero si Joey refused to accept. So, dahil ni-refuse o hindi inaccept ni Joey yung bayad ni Aljur, Aljur made a consignation. Nag-comply naman siya sa lahat ng requirements, okay? Granting he made the proper consignation. And so, after the court canceled the obligation, Aljur withdrew the deposit after securing the consent of Joey. And later on, si Aljur became insolvent. So, paano nababayaran si Joey? So, question, can Joey now proceed against Ashley, yung guarantor, for payment of 10,000? Ito, sabi diba, if the consignation having been made, the creditor should authorize the debtor to withdraw the same. He shall lose every preference which he may have over the thing. The co-debtors, guarantors, and sureties shall be released. So, under Article 1261, Joey as a creditor shall lose whatever preference she have over the amount, and si Ashley as a guarantor shall be released.
And that's end the discussion about tender of payments and consignation. Thank you for listening.